The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer some frequently asked questions about Illinois child support. As a piece of foundational information, Illinois child support law changed on July 1st, 2017. So the first question we're going to answer is, what is the difference between the old law and the new law? According to pre-2017 Illinois child support law, basically it was a very simple calculation to determine how much child support an obligor owed. It was a percentage of the obligor's income that was a fixed percentage based on a economic table, a guideline that the court received. And the only factor was the number of children, so that percentage went up depending how many children were involved. The income of the recipient was not a factor. That was irrelevant. So even if a person who made $20,000 a year might be paying child support to a person who made $150,000 a year under the old law. Under the new law, the income of both parties is taken into account to determine the amount of the child support obligation. So the court uses economic tables to determine the total amount that the parties collectively are responsible for paying towards the child. And then it uses the relative incomes of the parties, the incomes relative to one another, to determine how much the obligor is actually going to pay. So a higher income from the recipient is going to reduce the amount of child support payments that the obligor owes. A higher income from the obligor is going to tend to increase the amount of those child support payments. Another question we get is, how is child support different in shared parenting situations? So that's the foundational layer of how the law works. But in a shared parenting situation, the law works a little bit differently. A shared parenting situation is when each parent has the child for at least 146 overnights per year. In these cases, the total pool that the children that the parents are collectively responsible for paying towards the children is increased by a factor of 50%. However, the amount of time that each parent spends with the child or is responsible for the child is now factored into the equation. That's not factored in unless it's a shared parenting situation. So if you spend more time with the child than you're an obligor, that's going to tend to reduce your child support, even though the total child support pool is increased by 50%. So in some cases, a shared parenting situation may cause your child support payment to go up. In other cases, it may cause it to go down based on how much time each parent spends with the child. People ask, how is child support affected when one parent is voluntarily unemployed or underemployed? Now remember that child support is based on each parent's income relative to the other parent. So what happens if one of the parents is voluntarily not getting a job, either to avoid paying child support or to get more in child support payments? Well, in these cases, the courts look at potential income, not actual income. So it's what they could be making if they were trying to get a job. So there's two threshold issues here, really. One is the unemployment voluntary, because if it's involuntary unemployment or underemployment, then courts will use actual income. The second issue is, what would their income be if they were fully employed or trying to be fully employed? So those are two things that are disputes that can be that each party has to prove before the court. But if you are receiving child support and you're voluntarily unemployed, that doesn't mean you're going to get more in child support due to lack of employment, because they're going to use the income that you would get if you were employed as the measuring stick for your child support. The flip side is, if you're voluntarily unemployed to avoid child support, that's not going to work. The court's going to use your income that you would have if you were employed to determine your child support obligation. People ask, how is child support calculated for college expenses? So child support is required for basically until the child reaches the age of 18 or graduates high school, whichever comes first. After that, there are situations like college expenses or post-high school education of any kind in which child support may be awarded at the discretion of the court, but it's not mandatory. So in these cases, unlike child support for minors, the parent seeking child support has to show that they have the burden of proving that child support is appropriate, and courts will look at several factors when determining this, including the financial situation of each parent, and that's not a factor when deciding whether to award child support when they're minors. It can affect the amount of child support, but not whether child support is awarded. Another factor is the child's aptitude and their desire to attend school. So if they're blowing off high school, they're probably not going to get child support for college education. So the threshold issue here is child support appropriate? The burden is on the person seeking child support to prove that it's appropriate. The second issue is the person seeking child support has to show how much is appropriate, the amount, and the parties can dispute how much should actually be paid. And these child support payments can be paid directly to the child, or they can be paid to the financial institution. They don't have to be paid to the other parent. Another question we get is, what if a child support obligor has multiple children from multiple other families and there's multiple child support obligations? How does that affect income? So to state this another way, we talked about your child support obligation is based on your net income. The more net income you have, the greater your child support obligation will tend to be. Well, does a child support obligation to another family serve to reduce your net income for a family number 2 so as to reduce the amount you're paying in child support to the second family? And the answer is yes. So this is a little bit complicated. It's one of the more complicated things we have to discuss. But basically, the idea is first in time, it gets more in child support. So the first child support order that's entered is not going to be, the net income is not going to be reduced by any later child support orders. But later child support orders for separate families are, the net income of the obligor is reduced by amounts that the person is paying in child support to on previous child support orders. So basically, child A, that is the subject of the first child support order, is going to tend to get more in child support than child B, that's the second of the second child support order that's entered, because the net income for child B is reduced by the child support payments that are already being paid to child A. But child A's child support payments are not going to be reduced by later child support orders that are entered in favor of child B. Kind of seems unfair, but that's the way the law is. So it's important if there is a multiple family child support obligation to be the first one to get into court to get your order entered, because you're going to get more in child support that way. Finally, we're going to talk about what happens if one of the parents gets remarried, either the obligor or the recipient. Basically, this is irrelevant to child support calculations. So the income of the second spouse is not going to be factored into child support. So if the person owing child support marries someone that's very wealthy, that person's income isn't factored into the child support obligation. It's based on the income of the person that is actually the biological parent. On the flip side, if the recipient marries someone very wealthy, that's not going to reduce their child support payment. Again, because the rationale is only the biological parents have an obligation, a legal obligation to support the child. So even though the step-parent may choose to use their income and probably will use their income to support the child, they're not legally obligated to. So the income of a remarried spouse does not affect the child support equation on either side. Now, another wrinkle is if one of the parties gets remarried and then becomes voluntarily unemployed because of it, because of the income of the other spouse, remember, we're still going to use their potential income, not their actual income. So voluntary unemployment based on remarriage still works that way. Just because someone chooses not to be employed because of the remarriage is not going to change the child support amount. So again, if we look at the obligor that's voluntarily unemployed because of the remarriage, that's not going to reduce their child support obligation. If we look at the recipient that gets remarried and is voluntarily unemployed, they're still going to receive the child support obligation that they would receive, the same amount they would receive if they were employed, meaning their child support is not going to go up because they're unemployed due to the remarriage. So we have a lot on child support at our website, learn-about-law.com. It's one of our most covered topics, and each of the things we've talked about today has a specific article and video that goes into a lot more detail on our website. So please check that out if you'd like to learn more. If you have any questions, please leave them in the comment section below the post on our website or below our YouTube video on our YouTube channel. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud. And feel free to give us a call for a free consultation at 630-324-6666. That's 630-324-6666. We offer free consultations in nearly every area of law, and we have offices all around Chicagoland for your convenience. Thank you so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.